Good morning, everyone. We're delighted to have you join us today. Welcome to our 7th Coffee Break webinar, Employer Obligations and Unemployment Benefits. I'm Kristin Bremer Moore, and I'm a partner in Tonkin's Labor and Employment Group. We are in the midst of a historic change of how we conduct business and our lives. I can tell you that at Tonkin Torp, we attorneys have been developing up-to-the-minute expertise to stay on the forefront of new laws and regulations related to the COVID-19 pandemic. We've designed our Coffee Break webinar series to provide you with practical advice for your businesses to thrive during this pandemic. We have 2 more coffee breaks scheduled. On July 23rd, you'll be hearing from Chris Moorhead, who will discuss how to enforce new pandemic workplace policies. And then on July 30th, Megan Ruther will be discussing how to handle a COVID-19 diagnosis in the workplace. Let me pause and make a note about this format. First, please know that we are recording this webinar. You do not need to sign a disclosure, and no private information of yours will be shared. Please know, however, that should you choose to use our Q&A section, your question may be recorded in association with your name. We have designed this webinar to include many of the questions about unemployment benefits we've received over the past 4 months. So hopefully I've anticipated your questions and I'll provide answers during this webinar. If not, feel free to submit questions in the Q&A section of your Zoom app. After my presentation, I will conclude with a Q&A session and will try to hit as many of your questions as I can. Because the situation is so rapidly changing, I may not know the answer or your question may be too nuanced or specific for us to address in this webinar format. And I welcome you to reach out to me after the presentation or the Tonkin Torp attorney that you usually work with. Finally, information presented here today as of July 9th, 2020 is not intended to be legal advice. There I am. All right, today we're going to talk about unemployment benefits. For 4 months ago, we were looking at unemployment benefits from a different vantage point than today. Businesses were reacting to new state mandates designed to slow the spread of COVID-19 coronavirus, which resulted in major transformations to the workplace. Many of these changes resulted in working from home or working staggered shifts in modified workplaces. But for well over 300,000 Oregonians, it has meant job loss or the loss of income through cut hours or decrease in pay. Today, we're looking at the complexities at the unemployment benefits through a new lens of returning employees to the workplace. Some employers are experiencing difficulty in bringing their employees back to work for several reasons. Some are related to COVID-19, and some are related to an employee's decision that remaining on unemployment is more beneficial, both financially and health-wise. This presentation is to help you understand unemployment benefits a bit better and what you need to know about unemployment benefits as you reopen your business and ask employees to return to work. The topics that I will cover today are an overview of unemployment insurance, or UI, the CARES Act and its enhancements to UI, other changes to benefit eligibility related to COVID-19, the employer's return to work considerations and hurdles you might be facing, employees' risk and penalties for refusing a return to work, as well as best practices for returning laid-off employees to the workforce. First, let's start with a very high-level overview of unemployment insurance. And I'm going to be specifically focusing on Oregon, but know that we all often give advice for California and Washington and the other Western states. But I will be focusing on Oregon today. So what is unemployment insurance, or UI for short? UI are benefits that are paid to individuals who are out of work through no fault of their own. This may be as a result of a separation of employment, such as a layoff, or the employee may still be working, but has experienced a loss of income due to a decrease in hours. Who is eligible? Well, generally, employees are eligible for any week they work fewer than 40 hours and earn less than their weekly benefit amount. In Oregon, that is $496 a week. Employees are eligible if they have lost employment or their hours have been reduced through no fault of their own. As it relates to the current COVID-19 landscape, this means that if an employee is being paid by the employer while the business is closed, they are not entitled to benefits. For example, if a business decides to continue paying employees while the business is shut down, sometimes we call that standby pay, the employee is not eligible for unemployment benefits. As another example, I have some clients who received Paycheck Protection Loans or PPP loans and decided to continue paying their employees even though the business was closed or there was not enough work for all employees. In that situation, the employee is being paid by the employer and would not be eligible for unemployment benefits. To meet the eligibility requirements, employees also must be paid a minimum amount during the base year, or the employee has worked at least 500 hours and earned wages during the base year. And at the most basic level, the base year is a 1-year period before a claim is filed. Finally, and the real focus of today, is to be eligible for unemployment benefits, an employee must be able to work, available for work, and actively seeking suitable work. Employee benefits are administered through state agencies that must follow federal unemployment benefit guidelines. The Oregon Employment Department is the agency that administers unemployment benefits in our state. Throughout this presentation, you may hear me refer to the Oregon Employment Department as OED for short, or Employment Department. Again, please know that each state has its own agency with specific regulations for administering unemployment benefits, but for this presentation, I'll be focusing on Oregon. Next, we'll turn to some of the changes in the unemployment system in the wake of the pandemic. First, let's focus on the CARES Act. The Coronavirus Aid, Relief, and Economic Securities Act was signed into law on March 27, 2020. It is a massive financial economic commitment on the part of the federal government to get businesses and workers through the pandemic. From the CARES Act, we have, among other things, the Paycheck Protection Program, or PPP, which many employers have applied for and received. And relevant to our discussion today, the CARES Act also expanded unemployment benefits in 3 very significant ways. First, the CARES Act created the Pandemic Emergency Unemployment Compensation Program, or the PEUC. The PEUC provides extra money for employees who lost work due to COVID-19. The PEUC adds 13 weeks of benefits to a regular unemployment claim, and in Oregon that's 26 weeks, for those who are eligible. The 13-week extension runs through the end of the year. Second, the CARES Act created the Federal Pandemic Unemployment Compensation Program, or the FPUC. The FPUC is most widely discussed, the most widely discussed perk of the federal COVID-19 funding. The FPUC is the $600 weekly benefit that those who are already eligible for UI will receive in addition to their regular benefit. I like to call it the $600 kicker, and this $600 kicker is available until July 30th, which is actually the week ending in July 25th. There is no separate application process to receive the $600 weekly benefit. Rather, it will be automatically paid when an employee receives their normal unemployment insurance benefits. That is, if an employee is eligible to receive even $1 in unemployment benefits, they will also receive the full $600 weekly benefit. Given the new surge of COVID-19 cases and businesses responding to the second wave of closures, we will see if Congress extends the $600 kicker benefit. So far it has not, but we'll keep an eye out for that and certainly alert you if that does in fact happen. Important for most of our clients here today is that businesses will not be charged for the PEUC or the FPUC benefits paid to employees. Rather, these benefits are being funded 100% by the federal government. Third, the CARES Act also created the Pandemic Unemployment Assistance Program, or the PUA. The PUA program provides unemployment benefits for those who are self-employed, independent contractors, gig workers, or employees impacted by the pandemic who are not eligible to receive regular unemployment benefits, likely because they were too new of an employee or they hadn't worked enough hours or been paid enough in the look-back period. The PUA has been a lifeline for many Oregon workers, and it's also rather historic. For the first time ever, independent contractors and gig workers have been specifically included in federal and state programs for unemployment coverage because of the CARES Act. This benefit also runs through the end of the year. To receive PUA benefits, individuals must have lost income because of the pandemic. For example, if your company has hired a freelance software engineer and then had to terminate that contract because your business was closed because of COVID-19, then that independent contractor will be eligible for PUA benefits, including the $600 kicker. If, on the other hand, the freelance engineer decides to hike the Pacific Crest Trail during the lockdown and terminates her contracting relationship with you, she is not eligible because the loss of work was not due to or because of the pandemic. Let me pause here and say a few words for those of you who hire independent contractors and have terminated or reduced your use of independent contractors during the pandemic. When an independent contractor applies for benefits through the Oregon Employment Department to seek these PUA benefits, the Oregon Employment Department has said that it will first evaluate whether the individual is actually an employee rather than an independent contractor. In the Employment Department's terms, the agency will diligently review if an independent contractor relationship actually exists. If it does, then the individual will receive the PUA benefits and the $600 kicker through the end of July. However, if the Oregon Employment Department determines that the individual is actually an employee, they will receive regular unemployment benefits charged to your account plus the $600 kicker through the end of July. And you, the employer, will receive a nice letter saying that you owe back taxes plus fines and penalties for misclassification. So we'll leave that dreary subject for another time, but just know that this may be a source of unwanted audits by the Employment Department of your independent contractor relationships. There's also another concern. Sometimes independent contractors may inadvertently list the contracting company as the employer. If you receive notice from the Employment Department that an independent contractor is receiving regular unemployment benefits as an employee of your company, you will want to contest that unemployment relationship immediately by timely filing a response and providing an explanation of the true nature of the business relationship between the parties. Now let's discuss how other COVID-19 laws have impacted unemployment eligibility. The Federal Families First Coronavirus Response Act, or the FFCRA, permitted states to temporarily modify their unemployment insurance laws regarding work search requirements on an emergency basis. So the Oregon Employment Department in March issued temporary rules that modified some of these eligibility requirements. Recall generally, to be eligible for unemployment under normal circumstances, the individual must be able to work, available for work, and actively seeking suitable work. Also, under normal circumstances, an employee will be disqualified from unemployment if they fail without good cause to accept suitable work when offered. The temporary rules provide exceptions for employees who are discharged, quit or fail to apply for work, or refuse an offer to work for one of the defined COVID-19 related situations listed here. Let's go through them briefly. Employees may still be eligible for unemployment benefits if the individual has contracted the coronavirus. Number two, the individual has been potentially exposed to the coronavirus and has been subject to a mandatory quarantine. The individual has been advised by their healthcare provider or by advice issued by a public health official to self-quarantine due to possible risk of exposure or spread of COVID-19. Number four, the individual's employer has ceased or curtailed operations due to COVID-19, including closures or curtailment based on the direction or advice of the government or of the public health officials. Number five, an individual is staying home to care for a family member or other person with whom they live or for whom they provide care who is suffering from COVID-19 or subject to a mandatory quarantine. This means that the employee is taking care of someone with whom they have a special and close relationship, which may not be a family member, so long as a special relationship exists between the individual and the person they're caring for. That special person needs care due to COVID-19 or an isolation mandate, and the individual is helping care for them. Number six, an individual is staying home to care for a child due to the closure of schools, child care providers, or similar facilities due to COVID-19. And recall, this exception tracks with the FFCRA, and we need to remember that childcare is interpreted broader than just school or daycare closure, but also includes summer camps or non-traditional childcare arrangements like a grandparent taking care of a child, as long as that childcare arrangement has been disrupted because of COVID-19. And number 7, when an individual is asked to work when it would require them to act in violation of mandatory quarantine or government directives regarding the limitation of activities due to limit the spread of COVID-19. For example, if an employee is asked to return to a business that has been ordered closed, like a barbershop before the recent phase 1 reopenings, they would be justified in rejecting an offer of employment and would still be eligible for benefits. As another example, if an employee is asked to return to the workplace where an employer has taken 0 measures to institute social distancing or the wearing of mandatory masks, the employee could say thanks but no thanks and still remain on unemployment. Also, if you're an employer that has temporarily laid off your employees with an intention of hiring them back when you're able, the temporary rules also relieve workers of the obligation of actively seeking employment, so long as the employee meets 3 conditions. That is, number 1, they are able to work. Number 2, that they stay in touch with their employer. This means that they give you updated and accurate contact information and return calls, which I know has been a problem. And number 3, are available to work when their employer calls them back to work. Now, let's look at how the Employment Department's emergency COVID-19 rules apply to the reopening of the economy. As more businesses start to resume in Oregon, we've heard from our clients that they are running into situations where employees either cannot or do not return to work. Depending on the facts, this may impact the individual's eligibility to continue receiving unemployment benefits. Let's run through a few scenarios. When you have called an employee back to work, but they decline the offer, saying they are sick with COVID-19, are they eligible to continue receiving benefits? The answer here is pretty obvious. Yes, a person sick with COVID-19 is eligible to receive benefits. As another example, what if you call back an employee and they decline the offer because their roommate was quarantined, and just to be safe, the employee believes they should be quarantined due to their exposure to their roommate? The answer here is probably no. The rule is that a person who is quarantined is eligible for benefits if they have been advised by their healthcare provider or public official to self-quarantine. But in the fact scenario I just gave you, if the worker has not been advised by a doctor or public official, say a state contact tracer, for instance, then they will not be considered available for work and they'll be disqualified from receiving benefits. As another example, let's say you've called back an employee to work, but some are refusing because the business can't follow social distancing guidelines issued by the state. Are they still eligible to receive unemployment benefits? The answer is yes. If the business cannot follow social distancing guidelines, the employee may refuse to return to work and will continue to be eligible for unemployment benefits. But in a situation that we're receiving a lot of questions on, what if the employees are just scared to return to work? And in their minds, there is no conceivable safety measures that will ever make the workplace safe during a pandemic. In this situation, the employee will likely be disqualified from receiving unemployment benefits. As long as your business can follow social distancing guidelines, as well as other safety mandates, the worker's refusal to accept a job offer may disqualify them from receiving benefits. Let's put a pin in this. So this means that when you're offering employees reemployment, the job offer should have more information than usual. We recommend that you include all of the safety rules that you have implemented and make affirmative statements that the workplace will comply with all health and safety regulations and recommendations, such as social distancing, sanitizing, masks, temperature checks, mandatory quarantine, etc. In the last example, let's say you've called back an employee to work. However, some are choosing not to return to work because they are making more money on unemployment benefits, particularly with a $600 kicker. Are they eligible for benefits? And the answer here is absolutely not. And the Oregon Employment Department has been very clear on publishing this fact. Even though the employee is making a rational decision to not return to work, because who could fault anyone for choosing to make more money and be more financially solvent for themselves and their families, nevertheless, it will render them ineligible for benefits. Importantly, employers cannot make unemployment insurance benefit determinations for employees. That determination can only be done by the Oregon Employment Department pursuant to the process outlined and governed by statute. However, it is a good practice to notify your employees of the risks they face if they refuse to return to work when called back by the employer. So your job offer should also include language about the risks of losing unemployment benefits if the employee refuses to return to work without a good reason. Let's talk about those risks and penalties the employee might face. If an employee receiving benefits is not entitled because they made false statements or representations of fact related to their unemployment, even if it was inadvertent or without knowing, or if they fail to disclose a material fact, the individual may be considered to have committed fraud. For example, if an employee fails to notify the unemployment department that they have refused a job offer without a good reason, the worker will be disqualified from receiving benefits. The possible consequences to that employee are the individual must pay back any benefit that they received that they were not entitled to. They will be required to pay a penalty between 15 and 30% of the amount of the overpayment, and they will be charged interest. To recoup these amounts, the overpayment, the penalty, and the interest, the Oregon Employment Department may seek wage garnishments from the employee's future employers. They may seek property liens, and they may recoup the money from the individual's state and federal income tax refunds. Also, individuals could receive up to as many as 52 penalty weeks. A penalty week is a week in which the claimant meets all of the requirements for receiving benefits but will not receive payment. For example, let's say Susie has received a 52 penalty weeks for failing to inform the employment department that she refused an offer of employment. If a year from now, Susie applies for unemployment and she's approved, she will have to apply those penalty weeks before she can start receiving payment. Penalty weeks can last for up to 5 years. So if Susie needs to apply for unemployment insurance again in a 5-year period, those penalty weeks that she received in 2020 will count and she will not receive any benefits for that period. And finally, employees face state and federal criminal prosecution for fraud. Workers should be aware that the Employment Department maintains a specific budget referred to as the Employment Department Special Fraud Control Fund. It's a lot of words, it sounds scary. That is to be used for preventing, discovering, and collecting unemployment benefit overpayments. And a note for employers. The Oregon Employment Department has requested that employers notify the agency if employees have been offered work and have refused for reasons other than those that are covered by the COVID-19 related exceptions. While there is no affirmative obligation on the employer to report disqualifying events, in other words, businesses are not penalized for not reporting, the agency strongly encourages assistance to prevent fraud and to protect the Unemployment Insurance Trust Fund. Now let's move on to best practices. Employers should assist workers in filing for and maintaining their unemployment claim while the business is closed or curtailed. Employers do this by communicating to employees who are laid off that the layoff is expected to be temporary. Of course, don't make any promises there. Number 2, recommend that they file for unemployment. You might even give them assistance on how to contact the unemployment department. Also, instruct employees to continue to provide you, the employer, contact information that is up to date. That has been a real issue for some employers who are not able to stay in contact with their employees when it's time to recall. And remind employees that they must be willing to return to work when recalled, unless they have a qualifying reason for declining or postponing an offer. For independent contractors, communicate with your business partners about the Pandemic Unemployment Assistance, or the PUA benefits, and pass along that when they file, They are not to name your business. They are to name their own business and provide their own EIN number or their own Social Security number. The second thing to do is when you receive notice of claims from the unemployment department, review them carefully to determine if there have been any errors, such as individuals listed that aren't even your employees. You don't even know who they are. Employees who have refused an offer of reinstatement might also be included in that list, and you might want to notify the employment department of that. And employees who have moved, maybe out of the state, and don't intend to return to the area, or even independent contractors. Those also could show up on your unemployment claims notice. If you disagree with a claim that has been accepted, prepare and file your response in a timely manner. Your response should include an explanation of the circumstances. For example, that you offered an employee a position and the employee turned you down for unqualified reasons. In this instance, you might want to provide the written job offer and the employee's rejection. Or, for example, if you have an independent contractor that shows up on your UI notice, you might want to provide any agreement that you have with that independent contractor, invoices, payment, and also an explanation of that relationship. In addition, you may want to make an alternative approach with your independent contractors to resolve the issue. It may have been an inadvertent mistake where they accidentally provided the contracting company's number instead of their own EIN or Social Security number. So just remind them that they need to provide their own contact information. You may suggest that they speak with their attorney, and you can also ask them to withdraw the filing and refile properly. Last, your return to work offer letter should include some of the following items. First, you should clearly state the position, the pay, the hours, and the schedule that the employee will be called back to. Number two, there should be a statement about your commitment to safety and compliance with the CDC and Oregon Health Authority requirements and recommendations. Number three, you should include a statement about your business's newly implemented COVID-19 related health and safety policies that are designed to prevent the spread of the coronavirus and keep your employees safe. And finally, you should also include a statement about the worker's risk for refusing to return to work without good reason. All right, I will now open it up for any questions. So the first question I have is, how are you as an employer to notify the employment department that an employee has rejected an offer for no good reason? So if you go onto the employment department's website, there is a toolbox at the very top of the website, and one of the most prominently featured subjects is report fraud. It sounds a lot scarier than it is. Again, some of these might be inadvertent, but that is how you would submit a form to the employment department that you've offered an employee a position back and they have refused without a good qualifying reason. All right, there's also a question about what is the difference between a gig worker and an independent contractor? And there's a lot of overlap here, but typically speaking, a gig worker is someone who is working for Uber or Lyft or any of the food services right now, DoorDash. And an independent contractor is someone who's in business for themselves, but is typically someone that you as a business owner are contracting with to provide services for your company. So generally speaking, those are the distinctions there, but they all sort of fall within the same category of non-employee, at least in terms of the unemployment department. Okay, I also have a question that says, on the slide for eligibility for unemployment insurance, if an employee refuses to return to work, when you say staying home to care for a person who is subject to a mandatory quarantine, does that also include caring for a parent who is at high risk because of an autoimmune such as diabetes. And the answer here is yes, provided that a couple of things. Number one is that the employee, the person has been mandated by a healthcare provider to stay home. And it sounds like here they have been mandated to isolate, and that employee needs assistance. So, or not the employee, pardon me, the individual needs assistance and needs care, and that employee is going to be caring for that individual. So then, yes, that would apply. And know that right now we're looking at it, all of these questions in the framework of unemployment benefits, but they also touch on so many things that our other presenters in these coffee series have talked about, including leave rights under Oregon law, the FFCRA, the new federal law, and also ADA. So there are a lot of touch points here. I've purposefully left those aside and have really framed this just around unemployment today. But all of those would potentially be impacted if you had an employee that's saying that they weren't going to come back to work because of one of those reasons that touch other laws. So I have another question that says, we have some independent contractors who filed for PUA back in March and April and still have not received benefits. Other than advising the person to continue to dial for dollars, very perfect way of saying that, is there another way to assist them? And unfortunately, right now, employers and business partners, as they relate to independent contractors, have very little control over what can be done to hasten someone's unemployment benefit claim. So yeah, they just need to stay the course and continue calling the employment department. Some of these questions are a bit too nuanced and specific, and I'm happy to follow up with you after this presentation and answer them offline. All right, well, we really appreciate you joining us today, and we look forward to seeing you in the future. And until then, working remotely and virtually and over the phone with you. Take care, be well. Thank you.